by Jessica Maya Marglin, who holds a BA and MA from Harvard University and doctorate from Princeton University, and currently she's a member of the School of Religion at the University of Southern California. So please, Professor Jessica.
Thank you. Can everybody hear me? I apologize for my voice. It's not at its best. But hopefully you'll understand what I have to say in any case. Thank you, Mayed, for this lovely introduction. I want to thank also the organizers of this really fascinating event for having invited me. It's such a pleasure and honor to be here and to share a little bit of my work with you today, with really a mix of people that I don't normally get to address. I feel like I'm often stuck in the ivory tower, as we say. So it's really lovely to be out a little bit more in the real world. And thank you also especially to Joshua Sadeh for that really fascinating and thought-provoking presentation. And I feel like it works so well to be on the same panel, because I feel like Joshua has sort of made much of my argument for me, in the sense that he's sort of given you the contemporary context to which I will hopefully add a little bit of historical background. So in other words, I like to think that what you just said, Joshua, will already convince everybody that what I have to say is perhaps somewhat interesting. So I want to start today, my focus actually today is going to be much more historical. I'm going to be mainly talking about the pre-colonial period, particularly the 19th century, but I'll reach all the way back to the Middle Ages. And then I'll bring us forward into the colonial period and a little bit up to the present day. And I'm going to be interested in particular in how Jews navigated family law in Morocco, both in Jewish courts but also in Islamic courts. So I'll start today with a story, and then we'll get into it a little bit more. In the summer of 1840, a Jewish woman named Miriam, who is described as the daughter of Nathan Marciano, wanted to get a divorce. Now, we don't know much about Miriam or her marriage. We know that she had a daughter, but we don't know why she wanted to get a divorce. We don't know if the marriage was failing, or if her husband was failing to support her, or if perhaps she had fallen in love with somebody else. All we know is that she wanted a divorce. But what we do know, and what is particularly interesting, is that Miriam, instead of seeking a divorce in a Jewish court, went to an Islamic court, went to a Sharia court, where she obtained a divorce according to Islamic law. She had two notaries public, Muslim notaries public, draw up a legal document which confirmed that she and her husband were divorced, that Miriam renounced all financial claims on her husband, and that she agreed to support financially their daughter until the age that her daughter would be married. Now, this is particularly remarkable because, as we just heard a little bit from Joshua, Jews in Morocco had their own legal system. There was a robust network of Jewish courts which applied Jewish law, and which normally would have had jurisdiction over matters of Jewish family law, like divorce. In other words, theoretically, Miriam should have been able to go, or should have gone, to the Jewish court to get divorced. Miriam's story gives us insight into the ways in which Morocco's pluralist legal system offered Jews, and in particular Jewish women, certain advantages that stemmed from being able to move amongst the various legal orders that coexisted. Now, I'm going to unpack Miriam's story a little bit more in the course of this talk, but first we need to sort of establish a little bit about the nature of Moroccan law and law in Morocco in the pre-colonial period. So what I'll do is I'll begin the talk today by describing the array of legal institutions which coexisted in pre-colonial Morocco and to some extent overlapped. And then I'll focus in particular on the question of family law and how Jews moved among Jewish and Islamic courts to pursue matters relating in particular to marriage, divorce, and inheritance. And then finally, I'll speak briefly about how this pluralistic legal system changed in the 20th century under French colonial rule first, and then how the colonial legacy has persisted into present-day Morocco. So, But first, just a little bit of background on Morocco's Jewish community, since I'm not sure how familiar everybody is with the history of Jews in Morocco. Jews have probably been in Morocco for something like 2,000 years. That is soon after the destruction of the Second Temple in 70 AD. We don't know that much about them until the Islamic period, but certainly starting with the Islamic period, we have a lot of sources. Now, one of the important things about Jews in Morocco is that probably since the late Middle Ages, Jews constituted the only non-Muslim minority that was indigenous to North Africa. So indigenous Christians either converted to Islam or they left. So certainly by the 19th century, Jews are the non-Muslims par excellence. And in the 19th century, Jewish communities in Morocco were, by the 19th century I should say, Jewish communities in Morocco were mainly concentrated in urban centers. The demographic statistics are a little bit hard to get a handle on precisely, but Jews probably constituted something like 3% of the total population. However, in many cities, they constitute a much higher percentage, anywhere from, say, 10 to even 50% of the population. So Jews had a pretty important presence in Moroccan society, outsized compared to their actual demographic weight. Now, the other piece of background that we have to understand is that pre-colonial Morocco was a legally pluralist environment with a number of different legal orders that coexisted and to some degree overlapped. Now, I want to just take a moment to define what I mean by legal pluralism. I imagine this is a term that's familiar to everybody, but basically what I mean is that there were various legal orders that applied different sets of law, but that also to some degree had fluid jurisdictional boundaries between them, and I'll talk a little bit more about that later. And then to another degree, and this is something that Joshua mentioned, the fluidity of the jurisdictional boundaries between these different legal orders allowed individuals to, quote, forum shop among the orders, right? Meaning, to some degree, choose the legal forum that they wanted to pursue a particular case in based on the advantages that that type of legal institution could provide, either because of the types of law that it applied, or because of its enforceability, or because of the personal connections that one may have with a particular judge, et cetera, et cetera. So we'll be talking about how this works out in practice, but I just want to sort of put us all on the same page in terms of the terms I'm using. Okay. Let's begin by looking a little bit more closely at how Islamic law understands the status of non-Muslims traditionally. Islamic law traditionally considers Jews and actually all non-Muslim monotheists to be dhimmis. Dhimmi comes from the Arabic dhimma, which literally means protection. The idea is that dhimmis were protected by the Islamic ruler and afforded both a number of rights and a number of restrictions. So in the realm of rights, dhimmis had the right to life, to liberty, to property, and particularly to the practice of their own religious tradition. Now, for our purposes, what is particularly important is that practicing your own religious tradition in the Islamic conceptual framework also meant applying one's own set of laws. So the fact of being a dhimmi entitled one to one's own particular legal institutions. Now, in exchange for all of this, dhimmis had to agree to a number of restrictions, which were mostly designed to remind everyone, Jews and Muslims, about the proper social hierarchy in which Jews were below Muslims, right? So this was not an equal society. Jews and Muslims were not equal, but Jews did have a set of rights which were guaranteed them by Islamic law. Now, in Morocco in particular, in the 19th century, the barrier, in many ways, the barriers separating Jews and Muslims were actually quite high. So you very rarely had intermarriage unless one of the parties converted, usually to Islam. Jews lived in separate quarters from Muslims. Often these quarters were literally walled off from the sort of Muslim majority city. And you know, to a large degree, the social worlds of Jews and Muslims are separate. However, and this is, I think, a kind of important subsidiary point, which I'll return to in the conclusion, the legal institutions that existed in Morocco acted as a kind of vector which allowed Jews and Muslims to transcend the social and legal barriers separating them. And to a large degree, I think, allowed Jews to become integrated into the broader Islamic society in which they lived. So let me speak a little bit more about the nature of Jewish courts in pre-colonial Morocco. As I said, as dhimmis, Jews had the right to administer their own set of institutions. I'm sorry, I'll slow down a little bit, excuse me. I have a tendency to speak very fast. And these Jewish courts had jurisdiction over all intra-communal civil affairs, meaning all matters between Jews, right, only involving Jews, that were non-criminal. Now, family law foremost among these, but also commercial cases, real estate, partnerships, debts, really almost everything except for criminal cases. However, any cases involving Muslims automatically fell under the jurisdiction of Islamic law, which meant that Jews, whenever they were involved in commercial transactions with Muslims, ended up having to use Islamic legal institutions. And this happened all the time, because Jews were very frequently involved in commercial relations with non-Jews, with Muslims. Let me just give you a quick sense about just how frequently Jews used Islamic courts, because this is important for understanding the sort of extent to which Jews were familiar with Islamic law. A Jewish merchant named Shalom Asaraf was particularly successful and had a lot of business with Muslims in the 19th century. I've worked on his family archives, and my research has shown that at the height of Shalom's career, over a period of at least 30 to 40 years, Shalom Asaraf went to the Sharia court on average about once a week, which is a lot. Now remember, Shalom is Jewish, okay? But nonetheless, he is constantly in Islamic legal institutions. Now, the fact that Shalom was constantly in these Islamic courts meant that he became very familiar with the workings of Islamic law. Indeed, he was so familiar with Islamic law that some of his Muslim colleagues appointed him to represent them in an Islamic court. In other words, Muslims hired a Jew to be their lawyer in Islamic law, under Islamic law. Now, technically, lawyers don't exactly exist in Islamic law, but we'll talk, or didn't in the 19th century, but we can talk about that further. Okay, so on the one hand, Jews are constantly frequenting Islamic legal institutions, mainly for commercial purposes, okay? So we're not yet in the realm of family law. The other important facet of the interaction between Jewish and Islamic law that I want you to understand is that as I mentioned, the boundaries separating the different jurisdictions were actually quite fluid. So there were instances in which Jews voluntarily went to Islamic courts, even for cases that technically fell under the jurisdiction of Jewish law. So for instance, when Jews wanted to buy real estate from another Jew, right? This was something that they had the right to adjudicate entirely in a Jewish court. But very often, Jews chose to go to an Islamic court instead, or to go to both a Jewish court and an Islamic court. And then what you end up with is these legal documents which literally record the same transaction on one side of the paper in Hebrew according to Jewish law, and on another side of the paper in Arabic according to Islamic law. Now, the reason Jews were interested in doing this had a lot to do with enforceability. Jewish legal documents were enforceable in Jewish courts, but not in Islamic courts. If a Jew was ever sued, or if a Jew's claim to a property was ever questioned in an Islamic court, if that Jew did not have legal documentation that was valid according to Islamic law to back up his claim, then he was basically without recourse. It didn't matter that he had a Jewish legal document. So obtaining these Islamic legal documents were like a guarantee, an extra set of guarantees for Jews operating in this legally pluralist environment. Now, and this is something that I think very few scholars have talked about, not only did Jews sometimes voluntarily use Islamic courts, but Muslims in pre-colonial Morocco also sometimes used Jewish courts. Again, this was mainly for commercial reasons. I've never found a case in which a Muslim chose to go to a Jewish court for something related to family law. It doesn't mean it never happened, but I haven't personally found that in the archives. But fairly frequently, Muslims took advantage of Jewish legal institutions, usually because there was some particular facet of Jewish law that did not exist in Islamic law. Now, I don't really have time to go into this in great detail, but if you're interested, please ask during the question and answer period, and I'd be happy to give you more concrete examples. Okay, so in sum, the Moroccan legal system is a legally pluralist system in which we have Jewish courts and Moroccan courts, but neither Jews nor Muslims are isolated in their respective legal spheres. On the contrary, there's a lot of movement back and forth, okay? And this movement back and forth is, I think, really crucial to understanding the nature of family law in 19th century Morocco, especially when it comes to Jews. Let us return to Miriam's story, with which I began today. So, again, we can't know for sure exactly why Miriam wanted a divorce, but we can make an educated guess as to why she chose to get that divorce in an Islamic court rather than in a Jewish court. Now, Jewish law, Jewish family law, only recognizes divorce that is initiated by the husband. Okay, the only way to get a divorce according to Jewish law is for the husband to give his wife a writ of divorce, which in Hebrew is called a get. And by that writ, by accepting that writ, she becomes divorced. If the husband does not want to give his wife a divorce, there's really very little that can be done. The court can try to convince him, but they can't force him, because if he is forced, then the divorce is invalid according to Jewish law. Islamic law, however, as I'm sure many of you are familiar with, has a provision for a wife-initiated divorce. Now, of course, the sort of modern trajectory of this type of divorce, which is known as khul in Arabic, is complicated and storied, but in the 19th century at least, this was a real option available to women, and not only Muslim women, but also Jewish women. So Miriam probably was unable to get a divorce in a Jewish court because her husband didn't want a divorce. So by going to a Muslim court where she could agree to this wife-initiated divorce in which she renounced a certain number of financial compensation that she was otherwise entitled to, she was able to pursue a divorce really despite the strictures of Jewish law. Now, in using this strategy, Miriam was actually in a long line of Jewish women who had exploited this difference between Jewish and Islamic law at least since the Middle Ages. We have evidence from the Cairo Geniza, which is a store of everyday documents, mainly in Judeo-Arabic, housed in a synagogue in Cairo and dating back to the 10th, even the 9th century, in which we have quite a lot of documents attesting to Jewish women's use of Islamic courts in just this way. Now, I want to touch on a couple other aspects of family law which Jews also chose to pursue in Islamic courts, and which give a slightly different sort of angle on what was attractive to Jews about moving between these two institutions. Let me tell you another story about our Jewish merchant Shalom Asaraf, whom I mentioned earlier. So Shalom passed away in 1917, and he left behind a very large estate because he was a successful merchant. He had 3 sons who agreed to divide up the inheritance according to Jewish law. But rather than just being content with obtaining a Jewish legal document attesting to the division of the estate, Shalom's sons also went to an Islamic court where they had udul, where they had Muslim notaries, draw up an Islamic legal document which ratified the division to which they had agreed. Indeed, they even engaged one of Fez's leading rabbis to testify before these Muslim notaries that the three brothers were Shalom's only heirs and that they had divided the estate according to Jewish law. Now note, this is a slightly different kind of use of Islamic courts. Okay, these Jews did not go to the Sharia court in order to divide up their inheritance according to Islamic law. No, they divided the inheritance according to Jewish law. And this is relevant because according to Jewish law, their sisters got no share of the inheritance. Okay, Jewish women, if there are surviving male heirs, are not entitled to any of the inheritance. Only if there are only daughters do Jewish women inherit. And Shalom had some daughters, but they were cut out of the inheritance because Jewish law says that women don't inherit if there are brothers. So they did not divide up the inheritance according to Islamic law. What they did was get an Islamic legal document saying that yes, they had divided up the inheritance properly according to Jewish law. Now, why would they do this? Presumably, Shalom's sons were worried that if somebody wanted to contest the division of inheritance in an Islamic court, if all they had was the Jewish legal document, then they would basically have no case before a Muslim judge because Jewish legal documents were not recognized as valid legal evidence in a Sharia court. So by getting an Islamic legal document that testifies to the division according to Jewish law, these Jews were able to, again, kind of add another layer of guarantee to their legal rights in this legally pluralist system. Now, I mentioned that there's this difference between Jewish and Islamic law in terms of inheritance, right? In this case, in the case of Shalom Asaraf, Shalom's daughters did not try to exploit the difference between Jewish and Islamic law in order to get a share of inheritance that would have been due to them according to Islamic family law, but not according to Jewish law. However, again, in the medieval and early modern period, you do see many women who did do precisely that, who did circumvent Jewish courts and ask for their inheritance according to Islamic law so that they would get a share which they otherwise would not have been due according to Jewish law. Okay, I want to speak briefly about how rabbinic legal authorities responded to these sorts of strategies that were engaged in by Jewish women and Jewish men. Now, it was often the case that Jewish legal authorities viewed this kind of forum shopping with a great deal of suspicion. Basically because the idea of, say, obtaining a divorce in an Islamic court rather than a Jewish court really could at least threaten the authority of Jewish legal institutions. And if you ask most Jewish legal scholars, they will tell you that Jewish law is very suspect of Jews ever having recourse to non-Jewish courts. Okay, that's the kind of traditional view. However, at least in Morocco, rabbis were actually very strategic about the ways in which they cooperated with Islamic legal institutions, and at times they deliberately required that Jews use Islamic legal institutions in order to bolster their own authority. So I'll give you just one example, again from the realm of family law. And this takes us back all the way to the early 17th century, not so long after the influx of the Jews of Spain, when the Sephardic rabbis in Fez passed a series of community ordinances, takanot in Hebrew, which required, among other things, that Jewish couples register their marriage contracts, both in a Jewish court and an Islamic court. Now again, why would rabbis have an interest in making Jews marry according to Islamic law in addition to making them marry according to Jewish law? The rabbis who wrote this communal ordinance explain that if a Jewish man had a penchant for disregarding Jewish law and sort of putting himself outside of the norms of the Jewish community, he might go off and leave his wife without the proper financial support, or even abandon her without giving her a proper divorce, which would give her no recourse for either remarrying or sort of moving on with her life. Now, when Jewish courts were faced with this sort of strong man, that's the term, Gavra Alma, that's the term in Hebrew, they had little ability to coerce these rebels, these rebellious Jews, because their main tactic of coercion was limited to excommunication, right, to putting these Jews outside of the Jewish community. But if this kind of Jewish man had already broken all of these Jewish laws, he probably, to a large degree, considered himself outside of the community anyway, so threatening him with excommunication wasn't going to do much. So in order to protect Jewish women from these sorts of bad husbands, rabbis mandated that they register their marriage contracts according to Islamic law so that they could sue their husbands in Islamic courts as well. Because again, Jewish legal documents were not valid in Islamic court, but if they had an Islamic legal document, then they had a leg to stand on in order to try to force their husbands to be good husbands. Okay. So I've given you a little taste of how this forum shopping among different legal institutions worked in the pre-colonial period. And in the time that's remaining, I want to just take us briefly into the colonial period and up to the present to give you a sense of how all of this changed. Now, when the French colonized Morocco in 1912, they did so with really two main goals in mind. Well, they had many goals, but in terms of their approach to administrative reform, they had two main goals in mind, which really stood in tension with one another. On the one hand, the French wanted to preserve the institutions that they found in Morocco. And on the other, they wanted to reform them. They had a mission civilisatrice in order to civilize Morocco and bolster its government, etc. So when they encountered this legal pluralism, they to a large degree preserved it in the sense that they kept the structure of Jewish courts and Islamic courts. But they also fundamentally changed the nature of these courts. First of all, they reduced their jurisdiction to only matters regarding family law. Now, just an aside, this category of family law is actually itself a modern creation. Neither Jewish nor Islamic law has a sort of category of family law inherently. And the French were the ones who said, well, we're only going to recognize Jewish courts and Islam and Sharia courts as having jurisdiction over family law. So first of all, the jurisdictions of these courts were reduced. Secondly, and most importantly for our purposes, the jurisdictional boundaries that had previously been quite fluid and allowed Jews and Muslims to go back and forth among these legal institutions were rigidified to a great extent by the French. The French saw this sort of legal fluidity as very problematic. They thought of it as chaos, right? There's no order, there's no centralization. So they thought it was very important to establish clear and firm boundaries between the laws, which meant essentially that Jews and Muslims, not right away, but after a couple decades of colonization, Jews and Muslims ceased being able to exploit the differences between these two legal systems. Jews no longer pursued divorce and marriage in Islamic courts, and Muslims no longer went to Jewish courts. Now today, as Joshua has told us, the French preservation of Morocco's pluralist legal system persists, but so do these rigid barriers between the different jurisdictions, right? So you don't really, as far as I know, and again, my research is really mainly on the pre-colonial and the colonial period, but my understanding is that in present-day Morocco, you don't have this kind of forum shopping. And that is really a legacy of colonial reform. In conclusion, I think there are a few sort of really broad points that I would like to leave you with. And the first is just very simply that law in Morocco was not synonymous with Islamic law and is still not synonymous with Islamic law. That law is actually much more diverse, and particularly that Jewish courts have been a sort of fundamental part of the Moroccan legal system since the Middle Ages. The second is that this legally pluralist system not only afforded Jews the right to administer their own legal affairs, but also gave them opportunities to protect their own interests by moving amongst the different jurisdictions that existed. And the Jewish women in particular did this to great effect to secure their own interests. Now, what is ironic and perhaps a little unexpected is that in modernizing the legal system, the French actually reduced women's ability to use law to their own advantage. And there were certain negative consequences for especially Jewish women in the centralization and modernization of the Moroccan legal system. Now, beyond the question of gender and family law, when we're talking more broadly about Jewish-Muslim relations, I think it's important to remember that, historically speaking, again, during this pre-colonial period of legal fluidity, Morocco's legal institutions acted as an important vector of Jewish integration into the broader Muslim society. So the fact that a Jew like Shalom Asaraf was constantly going to Sharia courts and was so knowledgeable that he even acted as the lawyer for Muslims was really important, and I think to a large degree also trickled down, and that's part of how I believe Jewish women obtained their knowledge about Islamic law, that this was actually something that Jews and Muslims were knowledgeable about together. And that with the colonial reforms, there was a way in which law became used not as something to unite Jews and Muslims, but again, something to divide them. And that is another part of the colonial legacy, is this sort of legal division between Jews and Muslims. So I'll stop there. I very much look forward to your questions, and thank you so much for your attention.
Thank you.